Hi, everyone. My name is Chris with National Parents Organization, and today I'm here with Brian Vandiver. He's with the Arkansas Advocates for Parental Equality, and they're out of Arkansas, and they recently just got the Arkansas law passed, and we're coming up actually on the 1 year anniversary, so it wasn't that recent. But we're here to talk today about the effect of the law and how things have changed in Arkansas since they have enacted shared parenting. So, Brian, thanks for coming on today. We're really excited to have you and talk about how shared parenting is really helping parents and children out in Arkansas.
My pleasure, Chris.
So tell us a little bit. I mean, the law was passed almost a year ago. What happened right after the law passed and what's changed, since the law passing to now?
Sure. So, for those watching, last year we passed in Arkansas what we call Act 604, and it was a monumental, earth-shattering act that we passed in Arkansas that did a lot towards promoting shared parenting. One of the biggest aspects of it is it changed the burden of proof so that to deviate from 50-50 joint custody, the judges have to find that it is in the best interest of the child not to award that by clear and convincing evidence, which is a huge shift from the standard preponderance of evidence that is most often used.
Yeah, clear and convincing. It's really the top level of evidence, isn't it?
Well, for civil courts, it is. Obviously, in criminal courts, you have beyond reasonable doubt. But for any kind of civil litigation, generally that is going to be the toughest burden of proof that you have. And it's not uncommon to have that burden of proof where you protect fundamental rights, fundamental interest, like the rights of children and the rights of parents to engage in that relationship.
And you were obviously a pivotal part of getting this law passed. What was that experience like? I mean, was there a lot of resistance like there are in a lot of other states from advocate groups, like the bar associations, that sort of thing? What was it like getting the law passed there in Arkansas?
Yeah, obviously we had opposition from the judges, from the bar association. We did have a handful of family lawyers join us and stand up and do the right thing and say that this is needed. We need this change. But those are primarily the opposition that we saw and that you see in other states, and it was a battle. I mean, we tried to engage in a conversation to see if we could find common ground. But at the end of the day, they absolutely were opposed to any type of rebuttable presumption, and that was our goal, was to pass a rebuttable presumption of 50-50 shared parenting. And so we believed very strongly that we had the votes to do it. And there was some history in Arkansas that kind of, I think, poured gasoline on the fire, so to speak, with motivating legislators to say, we need to do this in Arkansas.
So, you had a lot of resistance getting the law passed from judges and lawyers. What are they saying now that the law's been out there for a year? Are they advocates for it, or are they still against it?
It's interesting. I've had several judges and attorneys, family law attorneys, who privately have told me, "We're glad that this happened. This was needed," and it's kind of like they're scared to talk about it. They're scared to support it because they know there's such a resistance against it. But there are those that will say, "No, this is a good thing." And we've had parents who have contacted our organization who have absolutely said, if not for the new law, I may not have had a 50-50 result. And so it is having a positive impact in our courts. I've had lawyers tell me it has absolutely changed the dynamic of not only litigation, but settlement negotiation and mediation, which is a huge aspect of most cases because for those that may not know, most cases don't go to trial. 90% of these types of cases settle. And so when you change the dynamic of the settlement and you change the terms of what's being negotiated from the outset, you really put both parents in a more equal standing. And that was, obviously one of our goals. And then we've had judges who have told me, look, this makes my job easier because I know I have a true presumption. I know I have a starting point and they have to come with real evidence before I deviate from that. And so from that aspect, those judges who are aligned with that type of thinking, I think, are very supportive. Now, there are some holdouts across the state, and for whatever reason, they think that they need to have the discretion and can't be told what to do by the legislature and things like that. But I think at the end of the day, the law is the law, and they have to apply it.
So it sounds like the law has really reduced a lot of conflict in litigation and settlements across the state. Have you heard any specific examples of that, or have parents told you how much money they've saved for being able to get this over with quickly?
Yeah, I don't know that we'll ever have any hard numbers on that, but we have definitely heard reports that settlement has been easier, that resolution has been easier as a result of the law, and I would say that the shift has gone from litigation over petty grievances to maybe litigation over true issues that might really affect the best interest of the child. And so those are the cases that absolutely, should be litigated. If there is an unfit parent involved, then that needs to be examined. So we now the converse of that is we believe we may have seen an uptick in domestic violence allegations, whether those are true or unfounded. Those are for the courts to determine. But that, I think, is problematic, certainly if they're unfounded, false allegations, to try to get around our clear and convincing standard. Because if they can prove that there's a pattern of physical abuse, domestic violence, then that's one of the exceptions to our clear and convincing burden of proof.
Yeah, oftentimes we hear about that being called the silver bullet in a divorce case where somebody accuses the other of domestic violence. But in this case, they would still have to prove that there was domestic violence, right? And I think a lot of times the allegations are made, the proof isn't available, and the issue is dropped.
That's right. I mean, it still has to be proven that there's a pattern of that abuse by the preponderance of evidence to get out of the clear and convincing standard burden of proof. But, you hate for litigants and attorneys, especially, to throw false allegations around. And so I think, that's one area we may look at in the future. You can always improve, right? And there's always areas of improvement, work to be done. And so we're going to look at what West Virginia did and some other states have done to look at their legislation and the wording to really address, I think, false allegations of abuse.
Yeah, but once somebody makes false allegations, I think it really takes the credibility away from them with the judge, right?
Yeah, I think it does. I mean, if it's proven to be false, I think it really hurts that parent in the long run. And we've seen, I've not only seen that, but I've heard that in cases in Arkansas where you have false allegations of abuse, and that, you know, turns out to be, disadvantageous to the litigant making those allegations.
It always hurts or always helps to tell the truth in court, right?
Yeah, for the most part, it does. But it's just shocking what is allowed in family courts still to this day. Now, I mean, I'll admit it. We have a lot of good young family uh, court judges in Arkansas now that we've actually been involved and helped to elect, and I'm proud of the work they're doing. But at the end of the day, you still have some judges that are from another era, and whatever the law says, whatever you try to do to convince them of the social science behind it, they are going to be opposed to shared parenting. And those are the ones that we have to try to replace. And so we try to target those judges with judges that are of a more modern mind of shared parenting, blended families, and understand that is the new norm.
Yeah, we've heard reports in Kentucky where I've heard where judges aren't always applying the law as it is supposed to be applied. So, what do families do in that case when a judge basically ignores the shared parenting law?
It's tough because in that situation, your only avenue as a litigant is to appeal. Certainly there's a judicial ethics committee that litigants can file a complaint with. Um, we are actually examining whether or not some of the family court judges that testified against our law that was then Senate Bill 18 and now is Act 604, whether they should be recusing in these types of cases because of their bias in advance of it being passed. So those types of actions, I think, are things that parents can do in other states. Certainly, if there are these types of laws, shared parenting laws, and you've had judges make public statements against it, then raise that as a reason to have that judge recuse in your case.
Yeah, I think that's a really interesting kind of rabbit hole to go down because, when I looked up the ethics of judges and lawyers testifying either for or against, these types of laws, what the thing that I found out was they're really not supposed to have an opinion. They're supposed to just make the committees aware or the legislator aware of maybe the effects that it would have. But
Correct.
oftentimes they do testify with either a pro, usually an against opinion, and so
Correct.
that's ethically questionable right there in itself. And I think the legislators need to be aware of that.
Well, certainly in Arkansas, our legislators are aware of it, and we are examining it closely. And I can tell you that that's something that we're going to have a microscope on because like you said, the judicial canons, the judicial ethics rules certainly would allow judges to come and testify on an informational purpose only. But then to take that where they are taking a position against a bill, or for example, maybe in like Ohio, where the judicial the judges council is actually writing a competing bill to compete against House Bill, I think it's 508. So you have judges actively opposed to legislation, and you get into questions of separation of powers. What is the proper role of the judiciary? And is it for them to be lobbying for certain laws that they are then going to be charged with judging and implementing? I think that crosses some ethical lines.
It definitely does, and has the potential to be disastrous if it's the fox guarding the hen house, if you will. So, what's next for Arkansas? You mentioned you were going to work on some of the domestic violence, false allegations issues. Are there any other things that you're looking at working on with the laws in the state?
We're coming up with a to-do list for 2023. Our legislature meets every other year for the main session. And so coming up in 2023, we're going to have a to-do list to improve our custody law and our child support laws as well, because obviously we're grateful that MPO recognized us as an A state on our shared parenting custody laws. We've got an F rating on our child support shared parenting laws. And that dichotomy is something we're going to look at fixing, because you can't, I mean, on the one hand, we're a great state for shared parenting and joint custody, but then that dynamic and how it plays out with the child support is terribly egregious for joint custody cases because there's really no mandatory consideration for shared parenting time. It's just up to the judge's discretion. So we're going to, examine that and some other things that we think are areas for improvement.
Well, it sounds like you guys have come a long way in your laws, but you still have a long way to go. And we certainly wish you the best. Is there anything else you want to talk about in the interview?
Well, we're just honored to be on today. We're celebrating, coming up on the 1 year anniversary of Act 604. We just want to make our Kansans aware of it, make those around the country aware of it, and for Arkansas to really be a leading example around the country for shared parenting and joint custody. And certainly, if anyone has any questions, please reach out to us, Advocates for Parental Equality. I'm honored to be a part of that group, along with Patrick Fraley and his wife Gina, who founded the group and have done monumental efforts to get Act 604 passed in Arkansas. We had, and then obviously want to say thank you again to Senator Alan Clark and Representative Jimmy Gazaway, both of which were our lead sponsors in the Senate and House. And without them, we wouldn't have been able to get this done. So it was kind of the perfect storm, the perfect team coming together in Arkansas. And we're really proud of the work we did.
That's fantastic. And where can people find you online? Is there a Facebook page, website?
Yes, we have a Facebook page and a website. Just Google Arkansas Advocates for Parental Equality. Find us on Facebook. We post pretty regularly there about mostly Arkansas issues, but national issues as well, and shared parenting. And be honored to interact with anyone who's looking for advice on trying to accomplish something similar in another state.
That's fantastic. And we'll definitely put links to those website and the Facebook page in the show notes so people can find those easily. And well, Brian, thank you so much for coming on today, and good luck in Arkansas. You guys have quite a ways to go, but you've made some amazing progress, and we congratulate you on that. And we're so happy for children and families in Arkansas. It's been a great win for them, and we hope that you continue to work so they can continue to see the benefits of how family law can change.
Thank you, Chris. Appreciate you very much.
All right. Thank you, Brian.